Okay.
Yep, it's all there.
Well, we're all getting much better at this as time goes on, which leads nicely into what I wanted to talk with you about today. So my job today is to tell you a little bit about how, as part of the public justice system, the Civil Resolution Tribunal has been managing during the pandemic, and maybe some of the lessons learned in terms of how we can increase the amount of resilience and flexibility in our public justice systems. So with that, I'll start by telling you a little bit about the tribunal. The Civil Resolution Tribunal is a part of the public justice system here in British Columbia in Canada. We have jurisdiction over a pretty broad range of civil claims, including neighbor disputes between people in condominium buildings, small claims disputes, $5,000 and under, as well as what's now the vast majority of motor vehicle personal injury disputes, so people who are hurt in a car accident. And we opened our doors in 2016 with a focus on online dispute resolution, but more than that, really a focus on human-centered design. The idea being that it's not enough just to put your justice system online, that if you care about access to justice, what you have to do is something much more difficult than that, which is to fundamentally reorient the justice system away from the needs and interests of justice actors like lawyers and judges, and towards the lived experience of the people to whom the justice system belongs. In other words, our goal is to take the justice system and bring it to people and build it around their lives, doing our best to take into account their limitations, their resources, their challenges, and so on. So how does this relate to the pandemic? Well, I think what we saw at the early days of the pandemic was a bit of paralysis. Before the pandemic, we had the status quo, and in a lot of systems around the world, what that means is we had a system that was not particularly accessible, that was pretty rigid, that was expensive to navigate, complicated, challenging, that didn't seem very inviting or friendly to people who were representing themselves or who could not afford a lawyer. And I think we could all agree that there is an access to justice crisis in many jurisdictions around the world, including in Canada. So that was the status quo before March of this year. And then when the pandemic hit, what we saw was a lot of court systems around the world just effectively shutting down for a time. And then when they did reopen, at least for urgent matters, what we did out of necessity in a lot of our court systems was have the status quo that remained inaccessible and unchanged, and then create a layer of technology on top of that, primarily through things like Zoom hearings, using platforms like the one that we're using right now. But of course, that doesn't fundamentally change the access to justice problems we had before. In fact, it just compounds them, because we know that every time you add a layer of complexity, including technology complexity, you exclude more and more people. So I would like to just take the opportunity to encourage us, to the extent that any of us are in a capacity to talk to public officials, or if we are in as actors in the public justice system ourselves, to think about how we can actually get to the root of the problem. How can we build a public justice system that is flexible enough and resilient enough to be able to keep on going through things like pandemics? And that requires us to do much more difficult work. It requires us to undertake a lot of culture change, a culture change that recognizes, again, that while lawyers and judges are experts in the law, people are experts in the realities of their lives, and we need to prioritize that expertise in the way that we design our public system. So with that, I'll tell you a little bit about the CRT and how we've navigated the pandemic. I mentioned that we are part of the justice system. We get invited to a lot of technology conferences like this one because of the online component of the tribunal. But I think what has allowed us to be resilient in the face of a pandemic is not really the technology part. We design everything that we build for the public in partnership with community legal advocates who represent those with the most barriers to accessing justice. We have a roster of advocates around the province who test and provide feedback on everything we do. And these are people who represent those with a low income, people who live in rural areas, people who don't speak English as a first language, people with physical disabilities, people with mental health issues, oftentimes a combination of circumstances as well. And so we've co-designed with them pretty much all aspects of the tribunal. So I don't think that it is the technology that necessarily builds resilience. It's the flexibility and understanding of what people's needs are. While court systems around us were largely shutting down, the tribunal stayed open 24 hours a day, 7 days a week. We didn't skip a beat. We had no downtime. And instead, that's allowed our 100 tribunal members and staff members to really be quite focused on how we can help the participants that we serve. We know that a lot of people are struggling financially and in terms of mobility and other circumstances. And so our team quickly pivoted in March to think about how we can make it really easy for folks to get extensions of time, how we can make our fee structure more accessible, and so on. So I guess the point is that resilience and flexibility are not about just using technology. Instead, I think what's allowed us to be flexible is our commitment to human-centered design. So human-centered design requires us to take into account people's different circumstances. And what's happened, I think, in the pandemic is that so many more of us are experiencing some of the circumstances that those who have the most barriers to accessing justice have always experienced. What do I mean by that? Well, many more of us have mobility issues right now. Many more of us are housebound. Many more of us are experiencing health problems due to COVID-19. Many more of us are experiencing economic vulnerability. And so if you can build a system that tries to take into account all those varying circumstances, that's what creates the flexibility and the resilience. It allows you to adapt quickly. It allows you to have choice built in. And to use an old analogy, it allows your public justice system to bend like a willow tree and not snap like an oak tree. And that's really what we've tried to do. So with that, I'll go through the tribunal a little bit to tell you some of the design lessons that we've learned, and I think highlight some of the things that have allowed us to stay resilient and flexible in the face of the pandemic. Our focus at the tribunal is not around making adjudicative decisions. I'm a tribunal member as the chair of the tribunal, and we have about 15 full-time judge-like figures who are called tribunal members in our process. But the other 85 staff members are really the heart of what the tribunal does. We treat adjudication as a last resort, but our focus is on collaborative dispute resolution. And the idea here is that human-centered design, at least for the kinds of problems we tackle, requires us to think about what people actually need and want. And mostly what they need and want when they have a dispute with a neighbor is to solve it quickly, with a minimum amount of money, time, and stress. And the way that we can offer them support and opportunities to do that is first by giving them free legal information and tools through an expert system that is based on the idea that if you ask people questions about their problem, you can use their answers using a very basic form of artificial intelligence to direct them to plain language, helpful legal information, and then also tools like letters that they can send to other people in the dispute to try and resolve the problem themselves. If that doesn't work for them, they can apply for dispute resolution using an online application form. We take care of serving the other person in the dispute so that they don't have to do that. And when the other person in the dispute comes into the process, the parties are invited to negotiate. That's the third hexagon in this slide. The negotiation platform looks like texting. It looks like WhatsApp or Facebook Messenger by design. Because one thing that we've learned, and this isn't surprising to those of you who work in legal technology, is that the more we can design things to look like what people are already doing, the easier it is for them to use and the more likely it is that they'll be able to use it successfully. And those rules that we know so well in the private sector also apply to the public sector. So our website, which I'll show you in a moment, looks like a very friendly website. It looks like the kinds of websites people see when they're looking for information or looking to purchase something online. So that's the negotiation phase. It's voluntary. And up until here, there's very little human involvement. But if a dispute can't resolve at the negotiation stage, then one of our tribunal mediators will step in, a staff person, and look at the communication between the parties and work with the parties to try to resolve the dispute by agreement. If people can reach an agreement either at the negotiation or the mediation stage, then we can turn that effectively into a binding court order for them. Last but not least, when all else fails, a dispute is assigned to a tribunal member. And this is really where we've exhausted any possibility of the parties being able to reach an agreement. And it's at this stage that the parties can upload their evidence and their arguments, exchange these through our portal, and one of our tribunal members reviews the material, decides to hold an oral hearing if necessary, and then renders a decision based on the evidence. But here is where I'm making the distinction between taking the status quo and adding a Zoom hearing and doing something like this. This process is based on all of the evidence in user testing and prioritization of vulnerable populations that we can do. It results in a process that is not focused on the judge role and that is not focused on adjudication, but rather is focused on supporting and empowering people to be able to be active participants in resolving the problem. And in the tribunal, we're really clear that the heart of what we do is based on this collaborative aspect. So we take a very non-hierarchical approach, or at least that's my approach to management, where the tribunal members are not at the top of the pyramid. The frontline staff members are not on the bottom of the pyramid. Everybody works hand in hand in a very horizontal manner to fulfill their role to help serve the public. So with that, I'll just show you some flavor for what this looks like. And I did also want to mention that although of course this is legal technology conference, a lot of the things that we do to improve access to justice have almost nothing to do with technology at all. And I would say if I had to identify the number one thing we do to improve access, it's using basic language. We have a rule at the tribunal that everything that a member of the public sees, whether it's our website content, all the way up to our tribunal decisions, like court decisions, all of that has to be written at the reading level of an average Canadian 10-year-old. And that's because that's the average reading level in Canada. So we use free online tools to be able to test this, but it's not really a technology function. And anybody in any court or any tribunal around the world could do that as well. That is singularly really increased access to justice because it means that people understand better what it is that's being asked of them. They understand the decisions that are being made about their lives. And it's challenging work, but it's really, really important and it's something we put a lot of effort into. So with that, there are some technology things we do too that I think are helpful. One is making sure that the technology just works well and looks good on a mobile device. All the steps I described earlier can be done on a person's couch whenever they want, 24 hours a day, 7 days a week. They can also do that when there's somebody who to help them, a spouse or a family member if they choose. That said, we also offer mail-based service, telephone-based service, and before the pandemic, in-person service in 60 locations around the province using government service points. One thing that surprised us is even before the pandemic, about 99% of people chose online services. And I think that is a product of, again, making it look very much like what people already do online. If you can press radio buttons, if you can buy something from Amazon, if you can FaceTime with family members, you pretty much won't have a problem using our technology. And I think that's been really key to success. So just a few screenshots from that first phase that I told you about. That's that expert system that uses expert knowledge, which we obtained through volunteer lawyers, and allows us to democratize access to that legal information to everybody. Most people cannot afford a lawyer for the kinds of disputes that we have jurisdiction over. And so at the same time, we know that people need that legal information upfront before they've started a claim to be able to make good decisions about what to do next. And that's what we try to do through the Solution Explorer. So we give people plain language legal information. We also collect feedback. You'll see that red not helpful button and the stars. And we use that feedback to improve the system very regularly. Our target is to refresh it every quarter. So we give people information, we ask questions, we give information, we ask questions. And then when we've given people enough legal information, we can pivot to giving them self-help tools. And one of the most popular tools is our letter templates, which are at this point tailored to all the information people have given us about their problem. So all they really have to do at this point is fill in their basic information, and they can email this from their phone or their computer. They can download it, they can print it. This is a really, really popular tool because people struggle to write formal sounding letters. And these letters already have all the relevant legislative provisions, deadlines, and so on. So not surprisingly, this is really popular. If people keep on going though, they can seamlessly apply for dispute resolution through our online portal. And they can do this from their smartphone. Our forms are meant to be really easy to fill out. Again, they were developed with community advocates who represent those with barriers in real time. They will help us beat up our forms and tell us what's wrong with them. And where that's led us is to develop forms which are really, really simple. This is not what will happen though if, as a pilot program, and I've seen this happen a lot around the world, a court decides that they want to start online dispute resolution and then sets up an advisory board that's primarily made up of lawyers and judges. I don't mean to beat up on lawyers and judges. I'm a lawyer myself. But when you prioritize lawyers and judges in the design of an access to justice project, what you end up with invariably is something very much like what you already have. Designing around the most vulnerable communities that you need to serve will result in something that looks fundamentally different. And I can almost guarantee you that if you design around vulnerable populations and then test with everyday random members of the public, what you develop will almost certainly also work for lawyers as well. But it won't look the same as our regular court system. And one of the ways that it won't look the same is that the court forms will be basic and easy to use and will not account for every edge case, no matter how rare. Same with the development of sets of rules and so on. And why is that important? Not to have giant forms that take forever to figure out, because we know statistically that every question we ask somebody increases the chances that they'll give out. So we really want to focus on the basic information we need to collect, and then you treat the edge cases as edge cases. You treat them as special handling opportunities. So I'm sorry for that. I know forms are very boring, but this is how you build in flexibility and resilience. It's how you mean that staff are enabled to handle the unusual cases when they come along, and we don't need to create encyclopedic rules and encyclopedic forms to be able to account for every possibility, no matter how rare. One of the ways too that I think we increase the humanity of our system is that we have basic forms, but we also ask questions where we know they're important for some segment of the population, even if that's a fairly small segment of the population. And an example of that is that we worked with LGBTQ plus organizations to develop questions about people's preferred pronouns, as well as how they would like to be addressed. And we make sure people know that we're asking so that we can address them respectfully throughout the process and use the right pronouns in our decisions and when we call people, for example. We also ask people if they need any special accommodation. This is another way that we try to even the playing field and add equity to the justice system, or at least our little corner of it. We ask people if they have difficulty reading or writing in English, if they have a visual or hearing impairment or mental health issue. And what happens is if somebody checks one of these boxes, one of our staff people will contact them and work out an accommodation plan to make sure that they have a fair chance to be able to navigate the system. And sometimes the solutions are really simple. And again, these are often really offline, non-tech solutions. But for folks with mental health issues, depending on what the issue is, a common request we get is can you just extend deadlines so I have more time to be able to respond? There's days where I can't respond all that well, and so I need a bit more time. For somebody with a visual impairment, it might mean relying less on written material and having a telephone mediation. So oftentimes the solutions are not too complicated, but the key thing we have to do is ask and really prioritize the experience of the parties that we serve. And lastly, one of the ways that I think we have really increased access to justice, and this is a design comment as well, is by really challenging the status quo. In many jurisdictions around the world, including here in British Columbia, when a person with a low income is looking to have their court fees waived, they have to go through extraordinary, often humiliating lengths to be excused from paying a very modest amount of court fees. In British Columbia, that includes having to get notarized affidavits. It requires you to figure out complicated court forms, a number of them. It requires you to go down to the court registry and to appear before a judicial officer in open court and to hopefully get your fee waiver order, only to go back down to the registry and do the thing you're there to do, whether that's challenging an eviction or something else. There's no evidence to support this. There's no evidence of fraud, at least in our jurisdiction or really across North America that I could find. I wrote a paper about this recently. And so when we were designing our system to excuse people from having to pay court fees, we made it as simple as clicking 3 buttons, and we've had no fraud. We only have about 3% of people who ask for a fee waiver, even though we don't check documents and we just automatically give the fee waiver to people. So why am I bothering you about something as esoteric as a fee waiver process in British Columbia? Well, because I think it's emblematic, it's symbolic of how we've constructed so much of our public justice system. We do it one time, often generations ago, based on assumptions about people, sometimes informed by bias and stereotypes, especially about low-income people, for example. And we just do it that way as long as it takes. We don't challenge it. We don't gather data. We don't base our decisions on empirical evidence. And I don't think that this is anybody's intention, but it just becomes the status quo that we don't challenge. And the harm of that is that we're hurting people. In the paper I wrote about fee waivers, it was clear that our current policy hurts people, that it causes a lot of people not to be able to challenge decisions that affect their lives because they can't navigate the process to not have to pay court fees that they can't afford. So one little example, but I think if we start pulling on these threads, why do we do it this way? Who is this hurting? What is the evidence to support? Is there an easier way to do it? Do we have to do it the same way we did it 50 or 60 years ago? I think if we shift our mindset to think really critically about that and start pulling on these threads, we find that a lot of these things unravel, and that creates an opportunity to do it so much better, better for the people that we serve, most importantly. So with that, I'll hurry on here because I know we only have a few more minutes left, but I did want to highlight again this key point that collaborative dispute resolution is so important. It's important because it empowers people to be active participants. It's important because it tends to result in more enduring agreements between people. People tend to do what they have agreed to do more than what they're ordered to do, even if that's by a judge, which is surprising to a lot of us who are in the legal system. Negotiation in our tribunal is voluntary. Mediation is not voluntary, though, it's mandatory. People have to participate in good faith. And the mediation success rate is actually very high because it's so flexible, because people can participate from an environment that they're comfortable with, and because the mediators are really skilled dispute resolution professionals. People don't have to agree, but they do have to participate in good faith. And then last but not least, we have adjudication, and that's where a tribunal member like me will make a binding decision based on the evidence. All of our staff and tribunal members were pretty much working from home even before the pandemic, and that has allowed us again to really focus on the needs of our participants. Our tribunal members are all experienced lawyers who work around the province, and I think I've covered almost all of this except to say that within 24 hours of the decision being sent to the parties, which usually happens by email unless they decide to have their decision sent to them in the mail. The decision's also published on a national database called CanLI, as well as on our own website. So it's a highly transparent decision-making mechanism. And I'll just end with this one other note, which says that if you're doing human-centered design and prioritizing user testing, this can't be a thing you do just before you open your doors. As those of you, of course, in the software field know, user testing and user engagement is an ongoing process. And in the public justice system, it should be no exception. So we do something that's pretty unusual for courts and tribunals here in North America, and that's that we ask people who have gone through the process what they think of it. We don't ask them if they agree with the outcome, because our decisions can be appealed to higher levels of courts in our justice system, but we do ask them if we treated them fairly, if they would recommend it to others, if we made a timely decision, if they understood what they were being asked to do. And we publish those statistics as well as both the positive and the constructive comments every month on our website. These are November statistics, which were up last week, so we do it pretty quickly after month end. And we also publish our annual statistics, so we aggregate all of these in our annual reports. And I'm happy to say that almost every month, we get really good scores on, did we treat you fairly? Did we treat you professionally? Would you recommend the tribunal to others? And I think that's really important in terms of making sure that we are discharging our mandate and staying glued to the needs of the public. Really, lastly, now I know it said that was my last point, but this really is my last point, which is to start to circle back to something I was talking about at the beginning. It's not good enough for us to take the status quo and add a layer of technology which we know will disenfranchise some people, even though it does technically allow us to keep our virtual doors open in a lot of areas of the justice system. That we should strive for something much more difficult in some ways, but also much easier in some ways, and that is to make human-centered design the key mantra of our justice system. And my experience in the CRT has been that building an inclusive justice system relies primarily on offline tools. And so these are some of the offline tools on the screen that we've used. I've covered some of them, but some of the basic things we do are having staff who are culturally competent, staff who are trained in mental health issues and talk to people in a respectful, empathetic way. Making sure that the community advocates who are serving those vulnerable populations have the phone line of a human to call if something's falling through the cracks for their clients. So I won't go through all of these, but only to say that even where we don't in our public system have a lot of public dollars to spend, I see a lot of courts talk about how they don't have big budgets. There's a tremendous amount we can do if we are humble and curious and talk to the people who are serving, and really do our best to build our process and our institutions around their needs. So with that, I'll end. Thank you again for the invitation, and good luck with the rest of the sessions today. Back to you, Natasha.
Thanks, Shannon. We have a few questions before you run off. The first one is, how long do you think it would be before more client-friendly legal services / designs would become the norm? Within the next few years, or do you think we've got a lot more work to do?
Well, it is a big job and we've got a lot of work to do, but it's exciting to see around the world different projects that are taking on this idea of human-centered design. When we opened our doors in 2016, there really weren't any other public justice examples of online dispute resolution or human-centered design that I could find. And now I'm lucky enough to be invited to speak around the world and do pro bono work around the world on this issue. And there are some really exciting things happening in England. It feels like every week in the United States, there's another court that's starting an online dispute resolution pilot, with Utah and Michigan being really leaders in that area. There's exciting things happening in developing countries as well, where there's a tremendous opportunity to leapfrog over some of the mistakes that we've made in some Western justice systems for generations, and really advance access to justice in places where there's obviously many more challenges than there are in places like Canada. So I'm very hopeful. I think a lot of exciting things are happening, but it does require us to shift our mindset. And I think that's honestly the biggest challenge that we have.
Just one more question, if we can. Have they had prior judicial experience outside the tribunal?
I assume this means the tribunal members?
Yes.
Okay. Some of them have had adjudicative experience, others haven't. Much like judges who are appointed to the bench, many of them come from private practice and have not had prior adjudicative experience. What we value when we're looking for tribunal members is a number of things. Obviously, subject matter expertise in the areas that we adjudicate. They have to be lawyers with a certain degree of experience there. But we also look at community involvement, pro bono service, and decision writing ability. So without getting into too many details, candidates have to write an anonymized decision writing exercise so that we know that they can communicate clearly and write careful, well-reasoned decisions. And we also want to make sure that people understand that our tribunal members understand the realities of people's lives. You can have a very experienced person who's practiced for 25 years serving business clients who may not understand how much the bus costs, how much milk costs, the challenges of taking on, childcare responsibilities and working at the same time. So we really want to have tribunal members who understand the lives of the people that they serve, because I think an unspoken thing in judging and adjudication is that the lens through which we evaluate evidence and people's decisions, what we decide is reasonable or unreasonable behavior, is very much informed by our own experience. And so understanding people and their lives is really core to, I think, building equity in the justice system.